Good evening, ladies and gentlemen. I welcome you all to the launch of Indian Handbook on Technology and Analytics for Law and Justice. I am Adya Pandey, your host for today's event. The book Technology and Analytics for Law and Justice is a unique volume from the DAKSH Center of Excellence for Law and Technology, IIT Delhi. We have gathered today for the launch of this book that seeks to answer crucial questions about technology's role in India's legal and justice systems. Our chief guest for today's event is Honorable Mr. Justice Rajiv Shakhder, High Court of Delhi, and we have Professor T.R. Sri Krishnan, Deputy Director Operations IIT Delhi, as the chair for the event. To begin the event, I request Professor Sri Krishnan to deliver the welcome address.
Good evening, everyone. This is, in fact, a very memorable event happening here when an area such as law is entering our Senate room, which normally deals with academics, that also in the STEM area, science, engineering, technology mostly. So I was just now discussing with the Honorable Justice Shakhder and my colleague Nomesh that this is a niche area where I am told that there is a clear lack of such resources to be used by people who practice. May not be for everyone and every. Of course, it is a very specialized thing. So it is very good that we are having this event today in releasing this book. So I first of all warmly welcome Honorable Justice Rajiv Shakhder to IIT Delhi.
Thank you so much.
And all of you who are gathered here on this occasion of release of this book. So welcome to IIT Delhi. Of course, many of you are from IIT Delhi, but still on this occasion when we are having this particular release of this very special book. So more about the book. Unfortunately, I am not really the expert or person who can tell you more, but I am sure that we have people here who are going to do that. So welcome once again. Thank you.
Thank you, sir, for your warm welcome speech. I would like to kindly request Professor Nomesh Bolia, IIT Delhi, and Shri Surya Prakash, Program Director at DAKSH, the editors of the book, to present the book to our esteemed chief guest to unveil it for its official release.
Surya. Okay.
If I can, maybe we'll request you to, hold this.
All of us.
Lecture, yeah, all of us.
Oh, yeah, all of us.
Yeah. This is the editorial council. Leah, of course, you know.
Yeah.
Deepak from IIT Delhi has also helped a lot with.
I would now like to request Professor Bolia to introduce the book to us.
Can I have the clicker, please? Slide change. So while the clicker comes, thank you everyone for joining us today. It's a Friday and an evening just before the weekend is about to begin, and it's very heartening to see the Senate room full with people on a Friday evening. The book comes after long hours, midnight oil, a lot of coordination, corrections, reconnections, spelling mistakes, all kinds of things that went on into making this. Almost 2 years is how much it took us from planning to execution, and fortunately we have the book today with us. My pleasure to introduce all of you, also a privilege. And nobody better than Justice Rajiv Shakhder to come here and release the book for us. So this is the title. Please have one look at it, fruit of lots of labor. All right, so, a book of this kind, interesting. We started off with much lesser in mind. our initial thought was maybe we'll wind the book up in maybe, let's say, 150 to 100 odd pages. And then it kept on increasing, and we kept on adding authors. These are some of the leading people in this space in the country, from leading institutions. Those details are all there in the book. So lots of thanks. Some of these authors are also here in the book. Some of my colleagues, Shaurya Shriyam is here. He's a co-author. Our colleague from IIT Kanpur was also here. Ashutosh is right here. Thank you so much, all of you. Big acknowledgement to all of you. This is the overview of the book. So it broadly talks about 4 things. It talks about how to think about technology in the law and technology space. We have taken a sort of broad view of law and justice.
To come this side so that we can see that.
Yeah. Can you move a little? Just a little bit. Thoda sa idhar ho jaiye. Yes. So law, justice and governance. So when we say law, we also mean implementation of law. And that's how a little bit of governance comes into it, particularly the areas which also have a lot of bearing on judiciary itself. There are chapters on identifying issues around technology and using analytics to sort of address those issues. Also chapters on how analytics can contribute directly to justice, in aiding justice, like we were discussing. No way, I think, do we intend to say that analytics and AI and all technology can essentially replace the core people in this sector, which are the judges and the other support staff. And it also takes a paradigmatic view of domains and illustrates that through case study. So it sort of tries to lay out a background, give a full framework, address specific and important issues, and also do some case studies. This is the structure of the book. So there are sort of 3 A's. We first start off with access, which is a big question. And then we'll go into assistance, which is how technology can assist the law and governance space. We specifically then zoom into analytics, so data and more data. Lots of ways in which data and analytics and aligned technologies can help. And finally, we end with talking about how institutions can approach and use these 3 A's, address these 3 A's. The first chapter is a landscape of the entire the space, and I'll talk about that briefly. And the last chapter then ends on a futuristic note, essentially saying if whatever is talked about in the book in the previous 21 chapters has to happen, what kind of transformations and changes do we need? Some of which are already talked about in eCodes Phase 3, by the way. So just laying it out and putting our perspective on that. So this is the first chapter, India's law and technology landscape. To our mind, one of its first ways of looking at things. We've come a long way. So, long back, pre-liberalization, we had technology entering various spaces. And then we moved forward. We somewhere in between, I'm sorry for the small image, but we had eCodes Phase 1, essentially talking about, hardware. And then eCodes Phase 2, which is software. I'll talk about that. There's something amazing that I liked about eCodes Phase 2. And then eCodes Phase 3, which is taking, much more than a quantum jump. And calling for cooperation from all sorts of stakeholders. So something amazing. This is, I think, small picture, but has taken, I don't know, many days, probably weeks and months of just putting it all together. So just, Aristotle, the reason why he's sometimes called father of science, because the first thing that he did is classified things. So we needed to classify this entire space, right? And so this is the classification. We felt, first of all, there are private initiatives and public initiatives. And then within public initiative, of course, the core things are justice delivery, governance and civic engagement, and law enforcement. Within private, there are things to make the job of practitioners easier. So legal practice management, specific customer services and support services. We've highlighted some of these, and we can come back to it if there are questions later. But I think this sort of way of looking at it, one, it tells us how far we have come in the last 2 or 3 decades. And 2, it also tells us where all we need to go forward, how things can really improve further. This is the first part of the book, access to justice. We made big leaps. It was very heartening to see the Chief Justice of India recently talking about how technology is a must, it's no longer a choice. That definitely enhances access. And then we were recently just now talking to Justice Shakhder also about how there is this initiative of converting judgments to Indian languages for better access. But there are also more things that can happen. So the first chapter talks about what are the issues there, including the digital divide. Although as a country, I think we are doing phenomenally well as compared to many other countries in terms of access to digital. But still, I think there are some space that we still have to cover. The next chapter is aptly titled Justice for One and All, where we frame this term called justice makers, or new kind of new breed of people who help legal redressal. So they're not judges, they're not lawyers, they're just helping common people, putting it all together. And then the next part is the second day, so the assistance. So broad brush of what all technology has done and can do. So for example, the chapter, I know I'm going fast, but the idea is to just give a glimpse of what all the book has delved into, right? And then we can come back to more details during the panel. So the first chapter 4 talks about how the legislature, it all starts with the legislature, the lawmaking, how they've used tech. The next chapter then talks about how technology has been used in land administration. By the way, this is one field where it has a deep impact on judiciary, large chunk of cases coming from this sort of the sector. Next chapter on technology in taxation, a chapter on how one can use technology for avoiding disputes. And then we had to get into it. Criminal justice system is a very important part of the law and justice space. So forensic technology to determine guilt or innocence. So what we've done in these chapters is, one, describe the technology, but also get into, I'm sorry, I think I jumped straight at the end of the book, end of the slide. Yes, so we'll need to bring it back up, Nitin. Just bring it back up, the full tech. So it does various things. It deals with solutions, the way technology has provided solutions, but it doesn't stop at that. It also talks about the issues that have come with those technologies, right? And I'll talk about that again in the next slide. So that was the second A. The third A is the A. Next slide. The A of analytics. This is the biggest chunk. Come to full screen, Nitin. So data, and more data. So various ways in which analytics has been used and can be used. So starting from basics such as looking at how data collection and what sort of improvements are needed in MCA 21. Come back, Nitin. Yeah. To looking at how public policy challenges can be addressed using artificial intelligence. Chapter 13 talks about AI and technology in law enforcement, and here particularly we talk about what kind of issues can arise due to the use of technology, biases, things like that. We talk about how AI can be used in legal data mining, talk about how AI can be used as a predictive tool for justice delivery. While there is a lot of talk about artificial intelligence, there are other terms to use similar technologies that have been in practice for quite some time. So operations research is one such term. For us, operations research, AI, they're sort of similar things. They look at things a little differently, but they're quite similar in several ways. So one chapter on how operations research can be used for the judicial system, and there's a whole variety of things that can be done. A specific example of how OR can be used in terms of optimal resource planning for the judiciary. And then finally ending with a warning on how all this data analytics is fine, but there are some very basic things that one needs to keep in mind. Finally ending with institutional focus. So first starting off in chapter 19 with how capacity building can be done and what sort of things we need to keep in mind while we do that. Chapter 20 talks about how startups, right? So this country is now a startup country, how they can play a disruptive role. And lastly, we conclude with an example of how such technology can, in a very specific case study of NCLT, help certain decision making. Finally, we end chapter 22 with the future of Indian judicial system, mapping the challenges and the opportunities therein. So like I said, phase 1 was more about automation, the hardware. Phase 2, building systems. And what I was saying here is, I think, we've not done an exhaustive survey, but I think our country probably has more data around courts out there in the public domain than any other country.
Yeah, that's true.
Millions, crores of cases out there with all sorts of details. One little issue that we had is we don't get it as one sort of dump to be able to do better analysis. But all the data being out there in public domain is simply awesome. I think it's amazing, and that's what phase 2 has enabled. And phase 3 has much bigger aspirations. And this note came to us also to IIT. We made some comments. Hopefully the kind of things that this talks about will actually be implemented, where various stakeholders, including the private sector, come together to address the problems in this space. This chapter also talk about how we can create enabling ecosystems. With the phase 3 document also talks about. And we map various challenges and opportunities like I just described. So one has to reach out to the citizens, one has to create a more responsive judicial system, and one needs to bring in the private sector through startups and various other initiatives. Chapter 16, so maybe I'll skim through this quickly. So OR is broadly the science of making things better. There is a whole bunch of technical terms that we use. The one on the left side, bottom left, network analysis, scheduling, decision theory, Markov, all of these things you'll also find in what is now called artificial intelligence. These are the kind of things that we do. What do we do them for? It can be used for, case flow management. It can be used for resource management. It can be used for analyzing, helping, litigants. All sorts of things can be done using this technology. Like I said, talked about various applications in the judiciary. This specific example of optimal resource planning for Indian judiciary. So very specific case, we looked at data available in the public domain, and the key observation that we had is even if we don't add to the number of judges, there are still some improvement that is possible in terms of our speed of addressing judges, and that essentially comes because various judges have different workloads and also what kind of sectors they are efficient in and things like that. So if you do that, mixing and matching a little better, looking at the data, some improvement is possible. And of course, if we add judges, much more improvement is possible. That a clear indication that reallocation of judicial resources can aid in improving the system performance. We'll consider the judiciary as the system. And of course, we're not claiming this is the final solution at all. We need to much more closely work with the courts before it can be finally implemented. But the basic idea is that it does show the promise of operations research in addressing this problem and multiple other problems. And of course, there is a whole bunch of other things that can be done using methods around this. I'll end with this one last slide. So, law and justice system, how it can collaborate with academia and other private sector players. So broadly speaking, there is a systemic aspect, right? So we analyze the system in case flow, for example, analyze what are the bottlenecks, see what more can be done. We analyze interventions for improvement, which are not only about bottlenecks and case flow, right? So reallocation, judge reallocation, calendaring, all kinds of other things that one can talk about. We can also help the practitioners, right, and the lawyers themselves through anomaly detection, prediction, typical AI tools that we have. But I think in addition to that, and this is not what the book really gets into, but this is sort of more of a vision for the future as well, where we use this all this technology also for the decision aspect, right? So while it can of course help in governance, once the decision is made to improve governance and to improve judicial decision making, it can also help and inform in the making of laws themselves. And just as an example, we introduced the policy of vehicle scrappage, right? And we said 15 years Delhi should get rid of its cars, right? Now, it could be a great decision, no doubt about it. But we tried to look into it. First of all, it took our team of IIT MTech students about 2 to 3 months just to figure out what exactly the law says. Because the government has something else on their website, and the NGT and the Supreme Court decision says something else, right? In terms of what should be done to the cars after 15 years. Very interesting. So something as simple as even making those things available, which what Japan does very well, our experience in some other contexts that we've seen, making those decisions and laws available in a simplistic way so that citizens can understand. That's one immediate thing that can be done. But a bigger question for us researchers is, is 15 years really the right way of looking at it? By scrapping things after 15 years, are we really reducing emissions? In fact, one can argue, and one can prove only after looking at data, that it could actually lead to more emissions. Because the idea behind removing cars after 15 years is that we remove all those cars which have become old and therefore are emitting more. But then the moment you remove a car, you also have to manufacture a new car because people are not going to leave cars. And then there is some which has emissions involved, and then there are some emissions which are involved in even scrapping the whole thing because the cars are not going to lie on roads. So if we account for all of this, is 15 years really the right thing? Or should we do something else? Should there be a policy of first checking whether the vehicle has actually become so bad before coming up with a blanket rule of 15? We don't know what the answer is. I'm being a typical academician here. I'll not commit to any answer. It merits further study. And maybe all decision makers involved in the entire ecosystem can involve researchers to sort of get into such decision making also. And that's where I end. It is indeed, I think, possible to have a scientific research-based policy and decision-making through judiciary. At least the e-courts phase 3 recognizes that very clearly. Thank you.
Thank you, Professor Bolia, for introducing the book to us. We now move on to the panel discussion on the book. We have with us Ms. Ravina Lalit as the moderator for the discussion. Ms. Ravina is a senior associate at Shardul Amarchand Mangaldas and Company. She is also a visiting faculty at Jindal Global Law School. Apart from that, she works with Her Forum, a platform connecting women in law. Ms. Ravina has worked on cases involving the technology space and written on the impact of technology in the legal profession as well. I would request Ms. Ravina to begin with the panel discussion.
Thank you everyone. Thank you for being here and thank you to our esteemed panelists. Just to give you a brief introduction about each of them, we have Justice Shakhder, who was an additional judge from 2008 and became permanent in 2011. He has done stellar work in his time at Madras High Court and continues to be loved in the Delhi High Court as well. And as a lawyer, he was practicing before various fora. He was also a lawyer for the union and also represented the office of the CAG. So today we'll get maybe diverse perspectives from Justice Shakhder's experience as a lawyer, as a judge, and across these experience verticals. Then, of course, we have Professor Bolia, who is a professor at IIT and coordinator of the DAKSH Center of Excellence for Law and Technology. He's also founder and director of Public Systems Labs at IIT. And we have Shri Surya Prakash BS, who is the program director at DAKSH. He's been working in this field regarding law and justice for over 7 years and brings with him rich experience of on-ground and research over all of this time. So thank you so much for being here. Just to commence the discussion after this very, very succinct summary of the entire book, my first question is to Justice Shakhder. We hear a lot about the misuse of technology. We've seen how technology can be helpful, but misuse, especially for us lawyers and in the profession. For example, ChatGPT making our legal petitions, to more serious things like using tech to, for example, automate our listings and cause lists. Do you think that would bring more transparency to our system, or does it become another tool for officials, for example, at the registry, to misuse their power?
Is it working?
Yes.
Yeah, thank you. First of all, before I answer your question, Ravina, I'd just like to thank the organizers for having us congregate over here. On a lighter note, there are, as I was walking into the portals of IIT, that there are two ways of getting to IIT. One is by passing the exam, and the other is by having you being invited for a book release. So I've got this opportunity here, and I was a science student who veered to accountancy and chartered accountancy, but my first love was law, and amongst others, of course. And then I took to law, and of course, she just told you, after law I became a judge, and I continue to enjoy what I'm doing. But there has been this disruption because of advent of technology, and it happened very vigorously when we were faced with COVID. And I can tell you, Nomesh, this is an experience that a lot of our young friends, brilliant students over here may not know, that Delhi High Court was one of those courts which had actually invested in technology quite early, and therefore we were able to cope up with the COVID-19 scenario that we were faced with, I think, reasonably well. In fact, some of my lawyer friends would tell me, would meet me often, that other courts were not able to deal with this kind of caseload while this virus was on, and we did most of our hearings sitting at home with lawyers sitting in remote locations, and we were able to navigate a very, very difficult phase. So, and it is at that time a lot of these initiatives got seeded in. In fact, the learnings have been very substantial and powerful. And to answer your question, now to come to your question as to whether there can be misuse. See, technology is there. You can always misuse technology. But as long as we build in checks and balances, that can be, that should not deter us from moving ahead. That's my take on this. So we had this incident very recently. You must have read in the paper that someone, and in fact this happened in our court also. One of my judges came to me and said, Justice Shakhder, there is an issue that I have. I said, what's the issue? He said, listen, there's an order in my name on a date when I was not even present. I was on leave. I was somewhere else. And then we discovered that the man had made a sort of a faux pas. He had actually done a ham-handed job, because the date of the digital signature that he had shown did not align with the date of the order, and we were able to catch. So technology can, in a sense, always be used as a sieve as well. But Ravina, I don't think that's something that really bothers us at this stage. What we do want, and I was telling Nomesh outside, is to help us reduce the complexity of the case. You see, we are burdened in Indian courts with numbers. I can tell you, with my experience sitting as a judge now for a decade and a half, that even with your best intentions, you cannot handle the numbers that we have. So something that I did tell him and the professor outside is, I tell litigants and lawyers, this is like a government hospital. I decide the priority. I decide who needs surgery today. I decide who will need surgery day after. So I do that scheduling. Now, where technology comes in is, if it can do intelligent scheduling for me, it may analyze my work and say, okay, Justice Shakhder can optimally handle X number of matters in a given day, schedule my board in a fashion where I can, deal with those matters and not have everyone wait, and give them dates which are reasonable, realistic. That's where I think technology will help. But maybe Delhi is not a great example. I'll tell you why. Because I went to Madras High Court. In Delhi, we have fixed dates. Suppose I take up a matter, I don't know how many of you have visited courts, but we always get a next date of hearing. You go to Madras, there is no next date of hearing. The judge says 4 weeks, it may or may not come back after 4 weeks, because the numbers are at least 5 times, if not more, than what Delhi High Court is. So they're not actually able to give you the next date of hearing. Now, if you were to employ a methodology whereby you would say, okay, now we are going to have dates, fixed dates in every matter. Your next date may be after 5 years. I don't know how litigants are going to accept that. And how does technology deal with this? Unless we do something which Singapore did, and they had someone who was not from the judiciary, they ruthlessly cut down cases, in the sense they decided this matter, allowed, not allowed, so much compensation, and then they got it to a manageable number. So that's what my take is on this. But anyway, shoot ahead.
No, thank you for that. I think it's very interesting, and the idea of probably getting judge-wise optimal number of cases for your board might be the best solution, at least for some high courts to start with. My next question is for Professor Bolia. So the book contains 22 chapters spanning multiple things, as we just discussed. What do you think is, or what was rather, your vision behind collating this book and coming up with this scholarship?
Well, so on a lighter note again, just like you began, that's what I'm supposed to do. Right? I'm a professor, I'm supposed to just put things together. But on a more serious note, for one major reason why I chose to become a professor at IIT and not get into a typical corporate job is, this motivation to create impact in the society, for the country, things like that. And, fortunately, my area, which is operations research, happens to be such that it can address challenges from almost any domain that you can think about. So I'm sort of free to, pick up which one can have the most impact. And after I joined IIT Delhi, I didn't have any exposure. Fortunately, I've not been in a court as a litigant. Or neither. I've been in a prison in the US, but not in India. That was out of mistake, sheer mistake, and the courts accepted and everything. But never here. So I've not had that brush with the law here. But interacting with people, just looking at these sheer numbers, things like that. The immediate first thing that I realized is, maybe some of the things that we do can actually, help ameliorate some of these situations. That's how it started. And then we started delving deep into it. We started this DAKSH Center of Excellence. We came together because of the initiative of the Supreme Court. They had called for some sort of a meeting. Justice Lokur was still handling the E committee that time.
Oh,
and that's
okay.
how we came to know each other, DAKSH and us. And we realized there are ways in which we can work together, and that's how the Center of Excellence started. And that's what got me even further deeper into the kind of challenges that this sector faces. And then we realized, well, there is no single compendium that talks about the entire landscape in terms of challenges, in terms of tools and technologies, gives a futuristic view, specific examples of solution. That sort of a thing just does not exist. One can have the best police in the country, one can have the best, governance in various sectors, but if the law and justice system doesn't work according to the people's aspirations, and I'm not saying it does not, I'm saying it really is among the most important sectors that one really can look at to create a positive impact all around. It affects, whether I go to a court or not, it affects every single person, right? And therefore we thought, there are these challenges, large impact, we can sort of delve in, we can put in our expertise, and we have DAKSH society to help us navigate, these contours, which we ourselves are not very comfortable with. We bring the tech part, and they bring the domain knowledge part, and the access part, talking to courts and other thinkers in this space. And so I think that's how we put all of this together. So to cut it short, not cut it short, I've been long enough, but to summarize, this motivation to do something for a very important sector for our national life.
Thank you. As a next thought, as in the legal profession, for example, various courts have moved towards video conferencing as a technology. The Supreme Court has recently directed other fora to follow suit. So it remains like a viable, permanent option for us as access to justice. We also have the use of smart contracts that are becoming popular across the legal profession. We have tools. For example, I use something called Citrix for my work, which is like a secure access remote desktop. You can manage it anywhere. So if I log out from my office today at 6 p.m. and I log back home on my personal laptop at 10 p.m., the screen will be exactly how I left it in office. So I don't lose any data and it's all secure within one space. So we have used a lot of things, for example, even e-signatures becoming popular, which have made processes much easier. But we still have a lot of deep-seated problems. For example, untimely transfer of certain judges from one high court to another. We often read about it, but there isn't transparency in understanding why that's happening often. We also have the issue, like Sir mentioned, non-listing of cases because of huge pendency. So these are more deep-seated problems. And I want to ask both Justice Shakhder as well as Professor Bolia, do you really think something like, process re-engineering can help us in terms of analyzing this situation and coming up with a better answer, or do you think these are only solvable through human intervention?
Go ahead, Nomesh. Have a first shot.
Yeah, so, we were discussing, before coming here, I think no amount of technology will completely replace human intervention in any sector, forget judiciary. And judiciary is among the last that will ever get, even sidelined by technology. So, human intervention will always be needed. And the reason why, that we were also discussing is all of this tech can really work on, first of all, it completely cuts out, the empathy, the human relationship, all the human part is completely cut off. But then also it really works on data which necessarily can only have insights from the past. Anything that is completely new, tech really can't do anything about it, right? So one has to have human intervention, for sure. Having said that, however, I'll not do injustice to my own breed. So technology definitely has a role. I think process re-engineering, the kind of process re-engineering that can be done in courts, for example, multiple sectors, you name it, hospitals, government, all kinds of sectors, schools, transportation, everybody has benefited from process re-engineering to a large extent. So, very simple things from much sophisticated things, all of those can definitely help and aid the judiciary significantly. We are ourselves doing a part of it in a very small way, and I think if the judiciary and, the other stakeholders that are involved here, if they take a super serious view of it, and try to get really involved and all, I think good stuff can come out.
Yeah. So, sorry. Can you hear me?
No.
Yeah. No, insofar as you referred to various aspects and then you went to process engineering, on the administrative side, simple things like transfer and all, no amount of technology can help you on that.
Yeah.
So, there are certain administrative issues which have other dynamics where machines can't figure out how human beings think. So that apart, this exercise of process engineering has already been looked at, done. There are reports. The question is about implementation. Again, the hump or the hoop that we have to cross is about the laws that or let's say the rules which operate in various courts. Now the presidency courts operates, which is a 150-year-old court, operates on separate set of laws. Delhi High Court is relatively young in comparison. We have our set of rules in which we operate. So for example, when a suit is filed or a suit action or any litigative action is filed, in good old days we had physical registers. So the suit action was traced from filing to issuance of summons, then filing of pleadings, etc., etc. And you have several such jurisdictions. You have original jurisdiction, which is suits. Then you have writ petitions, which are based on constitutional rights that the litigants have. Then you have intra-court appeals. You have inter-court appeals. So for all these jurisdictions, you had a whole lot of registers. Now the process engineering was that let's reduce it to something which is very simple. I mean, why do you have so many registers? So that exercise has been done. Where perhaps technology will be able to help us is that we have for India a pan-India, say, a register for each of these jurisdictions, and there is standardization. For that, we need to take a policy decision. And typically in India, it works top-down. So once that policy decision is taken, this is something that is doable and that can be done very quickly. You can give this, outsource this job, tell them these are the jurisdictions, these are the steps that are taken, and this is the pan-India platform you have. You have to populate it. Most of it get populated automatically with AI. So it's doable. They're working, but there is that policy decision that has to be taken. That's how I look at it.
Thank you. I think my next question...
Ravina, I just want to
Yes.
add
Sorry.
here. I think what Nomesh was referring to is in IIT Delhi DAKSH Center, sir. We have started work on simulation of case workload on code. And for that, we first realized that we have to map the processes. And a very nice mapping of commercial court appeals has been done. So when we talk about process re-engineering, first of all, you have to start with process mapping. Then you can figure out what to change. But process mapping itself has to be done. And I think there is a great advantage if these process maps, because these are not text, these are visual representations, if they can be put out in the public domain. The buzzword these days is digital public goods. So process map should be digital public goods so that everybody is aware. Registry, lawyers, litigants, everybody is aware that this is the process to be followed. It is available in textual form in various forms, but it has to be more accessible through a process mapping. I think that can go a long way in taking the next step. Like how sir mentioned, there are reports and the implementation side is wanting, but a lot of the energy now, I think, I'm very hopeful many things will,
So I believe, on all this, if someone were to ask for my personal opinion, is you need to scrap what you have and start again. That's the best way to do it. And then have a pan-India protocol. And that's how it should be. So everyone, whether he's in Madras, Pondicherry, or somewhere east, he knows this is the process that the court follows. But that's, again, as I said, it's above my pay grade. So
I mean, that's why we probably have so many law reporters that are very popular, because people get to see judgments, for example, in a standardized format with a headline text. It becomes easier to navigate. So perhaps, there is full merit in following that standard approach. My next question is actually on starting with the pendency point that you mentioned, sir, in your opening remarks. There is a chapter in this book on predictive analytics, which basically uses data from the past to help you arrive at a quicker decision based on predictive outcomes. Do you think that's something that could help judges resolve cases faster and therefore reduce the pendency issue? Or could it result in deepening of biases? For example, simple thing like transgender rights. If we go by predictive analytics, the previous cases might not give us an answer for today. But if for more complicated things like matrimonial rights, adoption rights, etc., where we always look at case-by-case basis, the same biases that exist against, for example, women in a lot of cases might continue. So do you think this is a tool that could really help, or will it cause more confusion in at least some types of cases?
No, so no, Ravina, my answer to this is that again, it's a tool which needs to be used carefully. And in certain jurisdictions where you don't have these kind of issues which you just pointed out. So say for motor vehicles accident cases, claims, it can be easily used because, and there is work being done on this quite vigorously, which is, you have an accident. We already have a system where the victim, if he survives or is legal heirs, don't necessarily have to file a complaint. The police generates accident report. It gets loaded onto the system, and if you know what the injury is, you get the medical report also. That's what they're trying to do online. And then there is the act, the provisions. There is a schedule depending on your age. What is the loss, pecuniary, non-pecuniary? It can be calculated very quickly. It's only where the insurance company were to contest it that a certain portion. They may admit certain portion, they may not admit, and therefore this is an area where they are doing work quite vigorously. I think Surya is aware of that. The other area is so therefore this is where we can use, and if you have past precedents, it makes the life of the judge very easy. He knows on this particular area there is already a decision that can be applied, and quickly a decision can be. It's a good area. 138, I mean check bouncing cases for example. There's another area where they are working on all this. So if it's a case of compounding where people say, okay, I admit I defaulted, I have to pay him, please schedule my payments. This is something that can be done. And then again they are working on this. But while we are on this, I must tell you, one of our, out of this 5 crores plus cases that we have, a huge number of cases are check bouncing cases. And you know why they are stuck? They are stuck because in our system, it's a criminal proceeding really. So you need to serve the defendant or the accused. Half your problem, or we did a number, it's about 30 lakh cases are on check bouncing, and 15 lakh summons have not been, 15 to 16 lakh summons have not been served. So typically the accused or the defendant avoids summon. They sort of tie up with the policeman, and then the judge can't do anything. He can't move because the law doesn't permit him to do an ex parte hearing as you could do it in a civil case. So necessarily the defendant has to be served. The fellow who has to be paid, he gets frustrated and he says, something that is there in cold print. I was given a check which bounced. I have taken all the steps which the law requires. Why I'm not getting my payment in X amount of time? But we are trying to solve this. In fact, we are talking to the National Payment Corporation of India and RBI so that they can give us the phone numbers and details whereby we can serve summons through SMS or through WhatsApp. The law needs to be tweaked because there are certain provisions that have to be navigated. So for these areas it's good, but for areas where it deals with sexual violence cases dealing with children, women, elderly, if you go strictly by past precedent, you may get stuck. And I can give you a good example of my own. So when I was doing this judgment on marital rape, and this is where machine can go wrong. If you go by a past precedent and if you pick up the bare language of the section, it says it will not be a rape. I'm just explaining to those who are not aware of the IPC section. It says it won't be a rape if it happens between an adult wife who's 18 and above and her husband. There's an exception in the rape provision, so he's not criminally liable. Now we were called upon to deal with this based on what were the past precedents and how the law should be, taking into account how the worldview has changed and how women want to be dealt with at par. I mean, they wanted a toehold in the whole process. Now, I don't think any machine, but the machine, if it's trained, it will pick up the law, the past precedents in India. It will pick up what the bare provision says and maybe give you a result. And Actually, someone did, try and test a ChatGPT program on this, because what happened is at the High Court level we had a split. I mean, we were two judges. My colleague took the view to sustain the provision, and I took the view to strike it down. When it was tested on ChatGPT, he said actually it's been struck down, because that was not the correct. So the machine does go wrong, and you cannot depend entirely on machine. So there are areas where this will not work. And especially as Nomesh rightly said, that there is empathy factor. It's just something that strikes you there intuitively at times as a judge. So
I think the check bounces are a fantastic example, sir, to talk about the point Nomesh made earlier about scientific database policy making. Before criminalizing check bounce, if there was some thought given as to what it would mean to courts and court processes and the judge strength, nobody even gave it a thought. So this judicial impact assessment needs to be pushed back more. The government needs to think through more on what it will mean to various sections of the society and the governance institutions. And this is where data modeling and data analysis can help even before it has an impact on courts. At the law-making stage itself, there should be a thinking through.
So I must add here, Ravina, predictive analysis is good for lawyers and for neutral evaluators whether a dispute should go to court or not. Unfortunately, and that's a comment, I have been a lawyer myself, in India, lawyers tend to take a chance. Why? Because litigation is relatively cheap as compared to the West. West, when they do a neutral evaluation, they will not go in for litigation if they apprehend the chances of success are remote, because you have to pay the actual costs of the other side. Here they say we'll take a chance and we'll see. We may come up before someone who's gets sucked in by our arguments and gives us an interim stay. So the process worries. Ultimately, they may not get success, but in an adversarial system, this happens. Like in a landlord-tenant case, the landlord may perhaps finally get his house. By the time he gets his house, the lawyer may become the landlord, and so that's the problem. The process and the wait is the difficult part. Yeah.
So if I can add something here, I think one problem that has happened in the modern world, in maybe this millennium, is that some parts of technology have become uber democratized. Everybody can use it, and that is the part that has been highlighted in terms of the ability to provide solutions. So one reason why, not the reason, but one reason why what is typically called artificial intelligence or any technology is considered to be so powerful is because it makes my day-to-day job of, for example, typing a message very easy. And everybody seems to have that pleasure, right? I'm typing something, wrong spelling, immediately correct, things like that. I think this leads to people getting a false impression that tech now can solve every problem. Because everybody is solving some problem on a daily basis, on an hourly basis maybe, right? The other technologies that have existed in the world, they have been probably solving deeper problems. Even artificial intelligence is also solving a lot of other deeper problems. They don't come to the fore. And so I think often stakeholders, not just in judiciary or government, but even in academia, even in all sorts of other ecosystems, they don't realize what else technology can do beyond the use of my mobile phone and some standard things. So I think one thing that I think must be done is whoever is using technology in a segment where technology is not a day-to-day affair, where they're not formally trained in technology, they should formally, informally, paid, unpaid, honorary, whichever way, consult with people who understand these things and who don't have any ulterior motives, right? No bad incentives. So identifying such people is a problem, but assuming that's done, where should we use technology and where should we not use technology? I think that's an important discretion that every institution must sort of get with the help of the relevant experts. I think
I completely agree with that. Yeah.
Sorry, just being conscious of time, I think just for closing remarks, just want to ask Surya Prakash ji, we've seen the book, we've seen the 3 A's, and the book is quite, spoken about how we've moved and where we're going. But could you elaborate a little more on what the road is ahead and how we can navigate that?
Yeah, I think it's a very exciting road ahead. We've just started, and Justice Shakhder has been leading many of the initiatives that are going to have far-reaching impact across the ecosystem. And like how Nomesh was pointing out, the eCourt's vision does provide for such structures. So there are 3 ways to look at it. One is your institutional structures. How do these institutions enable participation? I'm taking as a given that there has to be a collaborative endeavor by all people involved, whether it is industry, whether it is academia, whether it is the governance institutions, which is courts and the government. All of them now have to work together, like how they are working together in every other sector. This sector will also now have to, learn from previous experiences, other experiences. Now, the institutional setups have to be geared towards that, which means to say identifying partners, identifying ways in which, an example that I read recently was when I'm sitting by myself, I'm conscious of my limits. But if I have to pick up a book, I need to know how to deal with it. It's an external object, right? So any system which wants to deal with somebody outside needs to have the wherewithal to know what to do with that external, right? So the institutionalizing of the ways in which you interact with the larger world has to be thought through. Of course, India is leading technology on many fronts, so I'm sure that will flow through to the justice system very soon, like how Justice Shakhder said, it's already started. Much more will happen once the data is made more open and other courts and areas open up. The academia needs to step up. I'm very sorry to say, Nomesh, technology academia has possibly been more open than the legal. The legal academia has not been engaging on these innovative sides at all. I mean, you could say that they are more concerned about the substantive aspects. These are seen to be more in the domain of administration of law and justice, and therefore seen to be another area which is not their expertise. But there definitely needs to be a new breed of people who will engage with these opportunities. Opportunities are there, a lot of work to be done. As the nation itself is pivoting to a much higher trajectory, socially, economically, these are bound to happen, but you can't take it for granted unless the institutionalization happens. There is a sense of it being more random if it is not institutionalized early in the trajectory. Otherwise, it can take very divergent course. But much to be done ahead and very exciting times.
Thank you so much, and thank you for this wonderful discussion. I think we see technology something as lawyers especially, we always look at how there are problems with technology, how we can penalize and catch it. Like I'm an antitrust lawyer, we keep looking at how technology is used to manipulate prices in the market, for example. But we can't appreciate it until we use the technologies that work for us to streamline our processes better and come up with better answers too. So thank you for that. That's really, really helpful. Thank you for this wonderful discussion. We can take questions.
Yeah, absolutely.
Yeah, if anybody has any questions, we could take a few right now. Yes.
Please introduce yourself and
Please introduce yourself.
I'm Virag Gupta, and my associate Gaurav Pathak has contributed one chapter for this book. And I was excited when I read that Justice Shakhder is coming. Sorry. I was excited when I read that Justice Shakhder is coming because I was privy to a matter where he issued a notice in a very important matter of K.N. Govindachar in June 2012. He was in vacation bench, and that went for 4 or 5 years. So regarding this check bouncing matter, when Justice suggested that we should get the data from NPCI or RBI, and there may be various challenges of the data privacy and the data sharing. So what I suggest that there are 15 lakhs matter where we know that summons are not issued. So in those 15 lakhs matter, if the complainant should be asked to provide the number of other party, so I think easily we can serve the summons and without going into the other domain, because getting the data from the other agencies may create various confusion, because there may be 10 numbers of Mr. Praveen Kumar or Santosh Kumar, other person. So complainant, those 15 lakhs cases we can identify through the artificial intelligence, and someone should be, a stereotype someone can be issued to the complainant to provide the WhatsApp number of other parties, and I think easily we can resolve, because in the check bouncing matter there are 3 types of confusions are there. Government is saying that automatically there can be credit of the money. Supreme Court has issued the guidelines. Then there are certain things that under Article 247 there can be special court and which has not been accepted. So I think 15 lakh summon issue can be resolved by issuing the notice to the complainant. That's my suggestion. Thank you.
I came here, looking for some answers on the social justice front. My name is Amita, and you speak about access and you speak about justice delivery. I was wondering why you couldn't perhaps look at the issue of under trials in this country. You could analyze, numbers pending, those who have served more than their sentence would have. You could bring in the IITs or the judicial academies into the picture, and you would really bring about some, unclogging of courts and prisons as well. And that will be a great, big, step forward for India in its 75th year. I'm often told that government is the biggest litigant. How can you unclog this? Can you analyze what are these terrible tax authorities going after, citizens who anyway as a small minuscule pay taxes, and they are being, harassed and hauled up before? Can you analyze those issues? Can you look at a report card for NALSA, for instance? The Legal Services Authority. Why are they so unable to reach out to, people maybe living under the flyover right in front of IIT for years? Families living there with children. What causes our rural migrant families to come and live under flyovers? It can't be that attractive, for God's sake. So where are you in the social justice scenario? All I've heard about is cars, I've heard about taxes, I've heard about the private sector, I've heard about, what are the other chapters? I've made a note of all that, avoiding forensic, all of that. But where are you placed in the social justice scenario? And I wish you could make a difference there. It's a pity that our best brains really don't address India's real problems and issues till things come to a boil. Can you look at also convictions in, in areas where, for instance, if you read the book Framed as a Terrorist, the guy spent years in prison only to be acquitted. What kind of compensation should be due to him from the state? What does it cost his reputation, for God's sake, to be just picked up? Look at the conviction rate of CBI, for instance. And today we know that all 4 arms of the government are just going after dissenters and detractors and political parties and all of that. So where can you come in really and do something of substance in this country? And that would be my request to you. Thank you.
Yeah, can I just answer this for Amita, please?
Sure.
Because Amita has raised a very important issue. See, Amita, as far as...
I'm an advocate too.
Oh yeah, that's great. And an engineer. That's the best combination. In fact, we are going to have engineer lawyers and engineer judges very soon. So, no, Amita, to answer your question, what is being done on UTPs, that is under trial prisoners, NALSA has been doing a lot of work. You must visit their site. In fact, the Supreme Court has set up a monitoring committee for under trials, and a lot of these people are being released.
But not enough. Not enough. Too little.
No, you look at the numbers. You look at the numbers, and then that's what Nomesh is saying. We have impressions. Look at the data, and then come back. They have been doing so. Where credit is due, I think we should be reasonable and give them that credit. But I am not saying the problem is over. Yes, you're right. People get lodged in jails, and since courts, the process takes time, and sometimes people get acquitted after years, and that's a sad state. Yeah, state should compensate them. I'm completely aligned with your view, but
and where the government is a litigant, the biggest litigant of them all.
Yeah, so therefore this tool like predictive analysis is something that the government can and should use. I'm today handling a tax roster. I know, and judges who've preceded me on that roster, and I've also done this roster. Now I head the roster. Earlier I was the puny judge. Is 80% of the cases they finally lose. The revenue loses. But they will never do a predictive analysis and tell their bosses, this is not going to fly. Why? Because he doesn't want to, be hauled up for something years later and, be. So the government has to take a policy decision that we will do evaluation. What are the past precedents? What is the issue? Will this actually fly in court? Save us the trouble of having the matter there, hearing, passing an order. All this takes time. But there are certain things which other wings have to do to help reduce the burden. And if 90% cases in the court are, filed by the government, then yes, that's the biggest litigant, and then I can deal with the lists involving individual and a company, etc., etc. So that's a problem. About other things, of course, that's a general comment. I can't respond to that.
या थैंक यू सर. मेरा प्रश्न जस्टिस राजीव सर से है. सर, गांव में अभी जो हमारा पंचायती राज व्यवस्था था उसमें पंचायत का मतलब ये होता था पंच परमेश्वर, और गांव से वो पंच परमेश्वर फैसला करते थे. हम अभी गांव में जो सिविल और फैमिली इशू है इनको पंचायत के माध्यम से क्यों नहीं ठीक करने, न्याय व्यवस्था को प्रमोट करते हैं. हर इशू के लिए कोर्ट आना, और कोर्ट आना गांव में इतना मुश्किल होता है कि बता नहीं सकते जब तक वहाँ रहें. कोर्ट आना बहुत मुश्किल है. उनको डिस्ट्रिक्ट आने के लिए 100-500 रुपया खर्च करना और वकील को फीस देना उनके लिए पॉसिबल नहीं है. कई बार वो न्याय से वंचित रह जाते हैं. तो हमारा जो पंचायत व्यवस्था आया है टर्म, वो इसीलिए आया कि पहले वहाँ पंचायत फैसला करते थे गाँव का. अभी पंचायत का काम फैसला छोड़ के बाकी सब हो गया है, दूसरे काम में फैसला खत्म हो गया. तो सरकार इस तरफ क्या कदम उठा रही है, सोच रही है कि पंचायत जो फैमिली और सिविल इशू है उसको स्थानीय स्तर पे सॉल्व किया जाए, इस तरफ क्या कदम उठा रही है सरकार सर, प्लीज़.
आपका शुभ नाम क्या है?
मेरा नाम सर चक्रभूषण पांडे है जी.
पांडे जी, पहले तो मैं सरकार के लिए स्पोक्स पर्सन नहीं हूँ, थोड़ा सा कन्फ्यूजन हो गया है यहाँ पर. बट एनीवे, जहाँ तक आप पंच परमेश्वर की बात कहें, ना पंच रहे ना परमेश्वर रहे, वो जब पंचायती जजमेंट होती है हमारे यहाँ, हम कहते हैं ये पंचायती जजमेंट है. बिकॉज आई टेल यू व्हाई. यू हैव कप पंचायत फॉर एग्जांपल. आप सोचिए, पंचायत ये एक कॉन्सेप्ट है, हमारे दिमाग में है. मे बी एक जनरेशन के लोग थे जो कम्युनिटी को साथ लेके चलते थे, फिर एक कलेक्टिव डिसीजन होता था. बट ऑफन आप उसमें देखेंगे कि वो डिसीजन नहीं होता. वो किसी मुद्दे को एसेस करके, जैसे कचहरी में होता है वैसे नहीं करते. वो कहते हैं हमने कहा ये करना है आपको. अब आप अगर विलेज में जाएं आज भी, वो डिसाइड करते हैं और वो मानना पड़ता है, या उसको कम्युनिटी से बाहर निकाल देते हैं. वो what the courts through NALSA again are trying to do is going down to taluks and districts, educating people about their rights and trying, पांडे जी जो कहते हैं हम alternate dispute resolution, mediation में उनको ट्रेन कर रहे हैं. और जो मीडिएटरी प्रोसेस है वो पंचायत प्रोसेस से मेरे हिसाब से फार सुपीरियर है. क्योंकि मीडिएशन, अब मुझे नहीं पता कितने लोगों को यहाँ पर ये पता है कि मीडिएशन में ऐसा होता है कि दो लोगों का डिस्प्यूट होता है, वो मीडिएटर बैठता है, वो दोनों से बात करता है, अलग अलग भी बात करता है, फिर जो सोल्यूशन आता है वो दो लिटिगेंट्स आपस में बताते हैं हमारे लिए क्या सोल्यूशन है. इट इज़ नॉट इम्पोज्ड. पंचायत जैसी जगह में वो पंच जो 5 बैठे होते हैं कहते हैं आपको यही करना है, उसके बाद क्या रह गया. तो वो कहाँ का न्याय है? ये हमारे दिमाग में है, हमारे पूर्वजों ने हमें कह रखा है. मगर कई चीज़ें जो पूर्वजों ने कही हैं वो अच्छी हैं, कहीं हमें शायद उसको चेंज करना पड़ेगा. और औरतों के लिए स्पेशली मेरा ये मानना है कि दे कैन बी वेरी हार्श. आप शादीशुदा हैं, आपके पति का देहांत हो गया, आप उसके भाई से शादी कर लीजिए. क्यों? क्योंकि प्रॉपर्टी बाहर नहीं जानी चाहिए. किस तरह का इंसाफ है? वो करना चाहे ना करना चाहे, जिसको वो कल भाई की तरह मानती थी आज उसको अपना पति बन जाएगा, ये कौन सा न्याय? तो ये सब चीज़ें हैं जो आप ये हमारे दिमाग में है कि ये परमेश्वर है, परमेश्वर एक ही है बाकी सब
If anyone in the panel has any final remarks, then we could hear those and close the discussion.
So I just want to thank once again Professor Sri Krishna, Nomesh, Surya, Ravina, and all others who have taken out time to come here on a Friday evening. I don't know whether you got bored to death or not, but I enjoyed this thoroughly. I wish we could have interacted more. And I told Surya told me, you come here, give a keynote address. I said, I hate that. Why? It's a top-down thing. You say something, people have to listen to you because they become captive for those hours. It's better to interact and have a dialogue. Yeah, thank you so much for calling me over here. God bless you all. Yeah, sure.
Moving further, we have with us Mr. Vikesh Dhyani, co-founder and director at Oakbridge Publishing. Mr. Dhyani has worked in various strategic and operational roles, including sales, marketing, product and business development, with 3 of the world's largest higher and professional education, learning and analytic research solution companies over the last 25 years. I would request Mr. Dhyani to say a few words on this occasion.
Thank you, Adya. Honorable Mr. Justice Rajiv Shakhder, Professor Rangan Banerjee in absentia, Professor T.R. Sri Krishnan, Deputy Director, editors for the book, Professor Nomesh, Bolia, and Mr. Surya Prakash, B.S. It is an honor and a privilege for us to have partnered with DAKSH Center for Excellence in Law and Technology, IIT Delhi, for publishing this groundbreaking collection of contributory chapters from eminent experts from the diverse fields of law, technology, policy, and research. What makes this book very timely and useful is the fact that great nations are built on a foundation of robust administrative, legal, and justice systems that enable and drive strong economic and social progress. The resurgent and aspirational New India needs such innovation and technological advancements for sustained growth and development to become a global leader, and hence the need for a stronger, efficient, legal, and justice system that helps attract global capital, talent, and technology. The distinctive publication originating from the DAKSH Center explores the transformative journey of technology within the legal and justice realms in India. It scrutinizes the metamorphosis of technology within the India's legal and justice framework, delves deep into the challenges and opportunities that technology brings, provides insights into current perspectives on the topic, and speculates about the promising future of this swiftly evolving domain. As we all know, the legal system can sometimes be a labyrinth of complexity and delay, a maze that even the most experienced legal professionals can sometimes find perplexing. I believe that this wonderful book will act as a GPS for navigating this maze and showing us the path towards progress and success. This book will captivate a broad audience encompassing researchers, policymakers, government bodies, technologists, law firms, practitioners, scholars, and students seeking an early glimpse into the transformation of legal and justice systems. At Oakbridge Publishing, it is always our endeavor to publish high-quality works that serve the diverse needs of professionals and academia. The larger purpose of Oakbridge Publishing is to be the strong bridge between knowledge creators and knowledge seekers, and this book is another small step in that direction as it delves deep into the ever-evolving world of law and technology. It enlightens us on the promising future of law and justice, aided by incredible developments in technology and analytics. I would like to thank all our editors and contributors for their meticulous research and scholarly works. This is our second book with the DAKSH team, with the first one being on constitutional ideals released in May this year. It has been a great pleasure working with the DAKSH and IIT Delhi team, and we look forward to bringing more such path-defining works in association with them for advancing the rule of law and enabling access to timely justice. I would also like to thank all our distinguished and eminent guests, Justice Shakhder, Professor Banerjee in absentia, Professor Sri Krishnan, Professor Bolia, Mr. Surya Prakash, Leah Varghese, who's assisted with the development of the book, and Mr. Deepak Gautam for giving us this wonderful opportunity. And I would also like to thank you all for patiently listening to me. Thank you.
Thank you, sir. I would now request Professor Sri Krishnan to honor our chief guest with the memento.
Yeah, I thought I got one when I went.
That was welcome.
Thank you so much, sir. Thank you.
I now request Shri Surya Prakash to kindly deliver the vote of thanks.
Okay, all of us are getting ready to leave, so I think it's best I wind it up soon. The first thing I want to thank is the authors. Many of you are here. Thank you so much for making time. Prachi, Ashish, Surabhi, Dia. I know I'm missing a couple more. Thank you so much. You've been so patient and stayed throughout the project, answered all our queries, and thank you so much. I want to thank Professor Bolia and the rest of the IIT Delhi team for having coordinated this so well to see this to fruition. And I want to thank the IIT Delhi administration for having supported the DAKSH Center of Excellence work so far and in the production of this book. Also want to thank the Infosys Foundation for having supported this volume, without which this would not have even come into existence. All the members at the DAKSH team, Leah, Harish, others who've contributed in many ways, and Justice Shakhder sir for having graced this event, and
Also the
wonderful
forward.
attending,
Also
and
the
the forward, fantastic forward. The first point itself is great. The first point that you're making in the foreword is leading to so many conversations for us.
Really? I
Yeah,
didn't know
the
that.
complexity categorization of cases is it's a great idea. And Dr. Sri Krishna sir, thank you so much. The media friends who are here, thank you so much for your presence, and the audience members. With this, I close my vote of thanks.
Thank you everyone for attending the event.
Thank you, sir.
This mugshot. We need a mugshot. Mugshot.
Oh, who are the authors? Let's do it with the authors. Come. Oh, hi.
ये देखा मैंने कहा आपसे मिले तो मुझे सर मेरे
Where are the authors?
Yeah, I think so.
Whoever is here.
Surabhi?